I am presenting some work that I did as a member of the team at the Singapore Management University Center for Computational Law on using constraint answer set programming as a tool to improve legislative drafting. Rules as code, as we have heard from various people this conference, including Dr. Witt, is a proposal for modifying the way rules, laws, and other rules are written by involving programmers in the drafting process and co-drafting in both natural languages and knowledge representations at the same time. This is recommended as a way to simplify legal application development, to improve legal software quality assurance, and importantly, as a technique to potentially improve the quality of legislative drafting entirely. So the argument there is that avoidable drafting errors will be more likely to be noticed and fixed at the drafting phase by virtue of the attempt to formalize the draft law and the opportunity to test that formalization. So our experiment was designed to see if there's any evidence for this benefit to the quality of legislative drafting, and to see whether or not the programming language SCASP is an appropriate tool for that task. SCASP is briefly a stable model constraint answer set programming language. It is quite unique. Our main motivation for adopting it was that it features a combination of justifications and natural language generation, which were both very helpful, but as we discovered, those were only some of the very useful advantages that it has for legislative drafting tasks. The use of SCASP and our approach to defeasibility, which we borrowed from the Flora 2 programming language, allowed the encoding to be isomorphic to the legal text, by which I mean one section of the legal text corresponded to one section of code. Even when, as in this example, the legal text indicates that the rule contradicts two other rules, one of which defeats it and the other of which it defeats. Using this approach to the encoding of the other rules didn't need to change in order to write the encoding for this section and express those defeating relationships. So to simulate this rules as code drafting process, I, as the legal knowledge engineer, encoded a literal interpretation of Rule 34 of Singapore's legal professional responsibility rules in the SCASP programming language. I also encoded a set of tests separately that reflected my understanding of how the law was expected to behave. We ran those tests, which resulted in test failures. If those test failures couldn't be attributed to errors in the encoding, they were referred to a legal review team, who then looked to see whether there were errors in my interpretations. If they couldn't find an error in my interpretation, or one of them, then the legal review team analyzed the text of the original law to see whether or not the test failure was potentially being caused by a problem in the legislation itself. Our hypothesis was that drafting errors that were revealed by test failures in this way would provide evidence for the effectiveness of rules as code as a tool for improving legislative drafting. One such drafting error was discovered, despite the fact that we had no previous indication that it was there, and we were only encoding about 800 words of legislation. After writing 25 tests, 4 of them failed in ways that couldn't be explained by coding errors or incorrect interpretations. The specific problem we found was in Rule 34.1b. The legal review team could find no coherent literal interpretation of the requirement that a business materially interfere with a specific legal practitioner, given the abstract way in which the word business had been defined later in the rule. The team determined that it would be more reflective of the presumed legislative intent to say that an executive appointment materially interferes, not a business. So as might happen in a rules as code style drafting process, we proposed an amendment to the text. That amendment was encoded as an alternative, and when we ran the tests against that alternative encoding, all of the tests passed. So our experiment provides some evidence for the rules as code approach in finding problems in legislative drafting. We also learned that SCASP provides significant advantages to the legal knowledge engineering task, making it possible to get more information about the behavior of your encoding more easily. We also note that writing good SCASP code is still more difficult than it would ideally be to be able to give it as a tool to legal knowledge engineers who are maybe not experienced programmers. And we also have concerns about how well the abductive reasoning features may scale. The code for our experiment is open source and available at GitHub at the address indicated. My thanks to the members of the legal review team and to Professors Gupta and Arias for their teaching me how to use SCASP, and to our funders.